Vamos a empezar. El kinder. Okay, vamos a comenzar. We're going to start. Do you need interpretation?
No, I don't think so.
No? Okay. Sometimes we speak a little bit of Spanish. Well, welcome everybody. We usually have more entrepreneurs coming a little bit late.
Okay.
So you're going to see them joining us later. This is, I can call him my friend.
Yes, you
We
can.
met like a year ago now.
Yes,
One of a leadership training we did together for like 6 months.
yes.
And then was crazy that he was part of EBCF in the sense of he's a very good friend of a lot of our donors. He contributes mentally and in another ways to the foundation as well. So very honored to be his friend, a gentleman with a lot of knowledge, a lot. So take advantage in the good way. He's great. He's my friend Rick Sudacom.
Thank you. Thank you.
Also very involved in the community. He's gonna tell you where his adventures are now and what is his passion now, right?
Yes,
We
I
can call
am.
it passion.
Thank you for that very warm introduction, Sophia. Sophia's a good friend. We went through a program called Leveraging Local Leaders, which is sponsored by the Vail Valley Partnership, which is our regional chamber of commerce. We learned a lot.
Indeed.
We learned a tremendous amount. So it's a pleasure to be here. I want to introduce myself. My name is Frederick Sudicum. I was a trial attorney for 45 years now. I have been a trial attorney for 45 years. I just announced to my partners my official retirement. I've been of counsel to the firm since I moved to the Valley in December of 2023. My background, my educational background, we didn't have a lot of money. I went to a state school, University of Missouri. I worked very, very hard. And I graduated at the very top of my class. It's Phi Beta Kappa is reserved for the top 0.5% of the class. And that's not because I'm super smart. I'm not going to tell you that because I worked very, very hard. And I then clerked for a judge, appellate judge, for a year, 2 years, then moved to Chicago and practiced law in Chicago for 43 years. And I learned, I specialized in contracts. I specialized in contract disputes, primarily construction and insurance disputes, but because they involve complicated contracts. But I handle all kinds of contracts. So Sophia thought of me when the issue of contracts came up. So here I am. But I'm a problem solver, and I want to solve the problems that you all are presented with. Could you introduce yourself and you just tell me a little bit about your business and how I can help you with your contract disputes?
My name's Jorge, and I'm trying to start a construction business.
Nice.
So
What trade are you in, Jorge?
I do everything, but mostly drywall and woodworking.
So you start like a carpentry drywall company?
Yes, sir.
That's all right, cool. And what is your name,
My
please?
name's Diana, and I actually work at a bank. And I'm here more so to see how I can work to help out small businesses.
Oh, awesome. What bank do you work at?
I'm at UMB Bank.
UMB, nice.
Yeah, and I'm branch manager there.
Oh, very well. Congratulations.
Thank you.
That's awesome.
I'm Daisy. I'm a member of the steering committee of Elevar. I love to come to learn. I am a business owner. We own a company, and last year we had some situations with contracts and lawsuits, so I learned a
A
lot.
lot.
Yes.
What's the nature of your company's
It's a
business?
cleaning business.
Nice, okay.
Yeah, but we clean mostly healthcare facilities.
Mhm.
So
So you're dealing with the county or with private
private.
companies? Okay, great. Thank you. Yes,
Hola, mi nombre es Luz y soy parte del comité directivo de Elevar. En este momento estoy en el proceso de crear una nueva compañía, así que por lo pronto necesito contratos, pero muy pronto.
thank you. What's the nature of the business that you're going to establish?
Consultorías y consejería para negocios y personas en finanzas.
Okay, finance consulting. Do you have a finance background?
Sí.
Good, thank you. Thank you very much.
My name is Maria and I'm with Helping Hands Vail Valley, a nonprofit that I started a year ago. And I would love some insight on how to part ways with a partner and
Okay,
how we can do that as,
amicably.
yes,
And do you and your partner have a written agreement?
none at the moment.
Okay, so it's a handshake partnership.
It's something we sort of started together and it's just kind of taken off. And
Oh.
now things are changing and ready to
Right.
move forward.
And what's the nature of the business that you and your partner established?
There's three parts to it. The first part is women's mental health and wellness. And the second part is shuttle driving. And the third part is kids camps.
Come on in, guys.
The third part is kids camps and events throughout the valley.
Yeah, I think I've heard it, but have you been in the Vail Daily?
Yeah, we have been.
Yeah.
Yeah.
Okay, thank you. That's Ricardo, right?
Yes. Yeah, my name is Ricardo. We specialize in ductless air conditioning installations. And I would like your help with protecting myself. Like, what do you see companies fail the most when they go to court and stuff like that? To prevent.
Okay. Hi, I think we met before.
Yes, my name is Mónica y tengo un proyecto para ayudar a mujeres en la menopausia, una vida más natural, más saludable y mi pregunta o mi concern es cómo proteger mi marca personal, porque ahorita soy creador digital. Quiero saber cómo proteger mi marca personal, mi voz y cómo no tener problemas legales, porque utilizo términos médicos y doy, ¿cómo se dice? Consejos de cómo cuidarse con suplementación.
Okay. Have you established a business?
No, right now, no. It's just digital creative.
Gotcha. Could you introduce yourself, please?
Yeah, my name's Jackie. I've been in the Valley for 13 years. I've worked in a lot of the spas as a massage therapist, and then I just started my mobile business at the end of last year.
Wow.
Yeah.
Yeah,
Hi, my name is Hema, and I'm looking to start a grab and go with fresh tortillas, flour tortillas. So something new.
great. And where will the grab and go be located?
I was looking for brick and mortar, but I'm having a hard time finding the location. So maybe shift the idea of starting with the food truck in the meantime. But I'd love to be able to find a place. Unfortunately, I haven't been successful.
Super. Could you introduce yourself, please?
Mi nombre es Ángel, yo soy barbero, tengo una barbería junto con un compañero y otros dos en Minto.
Awesome. Welcome. Nice to meet you.
Thank you.
And you're with your partner?
Yeah.
Great. Thank you. Well, welcome, everybody.
Thank you, sir.
It's a pleasure to be with you. So let me just kind of run through the slides that I prepared. So we're going to talk about the essentials of understanding contracts and memorandums of understanding. Has anybody worked with memorandums of understanding? Sophia, yeah, at the Eagle Valley Community Foundation. Yeah, so nonprofits tend to use these documents, and I'll go through them. So I'm retired. I live in Avon. I've lived there for 2 years. I was a trial attorney in Chicago handling contract disputes, and you've all been kind enough to introduce yourselves. So you had a contract dispute. You had a contract dispute. You had a contract dispute, and you went to court, and there were lawsuits, and you learned a lot. So there are basically 5 essential elements to having an enforceable contract. One party has to make an offer. The other party has to accept that offer. There has to be a meeting of the minds, meaning that they have to agree on the same thing. Then to be enforceable. So Sophia says, Rick, come and teach this class. And I say, fine, I'll come and teach the class. She tells me the date. And then there has to be consideration to be an enforceable contract. So Sophia says, Rick, I'm going to pay you $1,000 for this class. That is consideration. The final element is legal capacity, meaning the parties have to be legally capable of entering into a contract. So you say, okay, that's great, Rick. What does it take to be legally capable? You have to be over 18, and you have to be of a sound mind, and it has to be for a legal purpose. So, if Savannah Guthrie's, whoever kidnapped her mother entered into a contract with somebody else to kidnap Savannah Guthrie's mother, it's not a legally enforceable contract. It's not for a valid legal purpose.
What about renters?
Renters.
Can they do a contract or?
Yes.
Let's just ask if they're the owners or?
That's a very good question. If you are a tenant and you're renting from someone, yes, you should verify that they have the legal capacity, the authority to rent the property. You were going to get to this, but contracts involving real estate must be in writing to be enforceable. There's a statute, the statute of frauds, it's called, we learned this in law school. There are certain kinds of contracts that must be in writing to be enforceable.
Like a computer?
If you can print it out
Okay.
and get it signed, a valid signature, yes. But if it's just like an email, hi, welcome, no worries. You need some space here, yeah. So we're just talking about what makes an enforceable contract. Get yourself set up and we'll come back to that. There's those 5 basic elements. Any other questions about what it takes to have a valid contract?
If there's no signature, then it's not valid?
Correct.
What
Both
about,
parties?
The party against whom it's to be enforced.
So if I write the contract, you have to sign it?
Correct.
Okay.
But yeah, and if I want to take you to court and you don't have it signed, I can't enforce it against you. It has to be signed by the person who you're seeking to enforce it. So if I promise to pay you, you sign it, and I don't, you can't make me pay
I
you.
can't force you to pay me?
Yes,
So I would have to make the contract myself and then have you sign it?
correct,
Okay.
correct. Remember, meeting of the minds, what the signature signifies, what it does, it shows that you read it. It's presumed, legally presumed, that if there's a term in that contract and you sign it, you know what you're doing.
What about if you said like paying the deposit and then you sign it or something like that?
Yes. Paying a deposit,
Yeah.
all right, so that's consideration, that's one of the elements that we need. That's consideration.
But it's not enough if you just
You still need a legal capacity, meeting of the minds, a signature, offer acceptance. So that's, that's one piece, but it's not the only piece. It's a good piece. So we took the statute of fraud, what contracts must be in writing? When I say must be in writing, what I mean is must be in writing to be enforceable. Agreements that are to be performed over more than 1 year. You have a construction company. If you've got a contract to, do building for a big land developer over 2 years, it has to be in writing to be enforceable. So if it's to be engaged, if your services are going to be performed over more than 1 year, must be in writing.
Rick, one thing that happens to me many times, I have some entrepreneurs coming to me saying they usually work as a contractor.
Yes.
Not really, because sometimes they pay cash.
Right.
So they have their construction mostly. There were 2 cases that were construction. Okay, so my boss says, go work on this house, verbal contract. I don't know, that exists here. And I'm gonna pay you $50 an hour, and you're gonna do this, and okay. They finish the job, they're gonna get paid. The boss says, okay, no, I didn't say it was 50, say it was 40.
Right.
So now how can you dispute that? And I say that because it was 2, like seriously, 2 guys that came to me in that. And I said, did you ever have an estimate? Did you say, okay, I will do this? That's an estimate? Is that a contract? No, because it's like.
It's an estimate. So that's a very good question. So here's the thing. The contract to be enforceable, unless it's one of these specified contracts, doesn't have to be in writing to go to court and enforce it. However, if there's a dispute, I say 40, you say 50, what a judge is going to do is he's going to listen to both sides. And if he believes one person is more truthful than the other, then he could fine for them. But frequently what judges will do is they'll say, I don't know who's telling the truth. So what they'll give you, the person who performed the services, is the reasonable value of your services. So the estimate might be evidence of what is the value of your services. So, it's not everything is lost, but if there are vague terms, but an enforceable contract, judges will throw it out, and then they'll impose a reasonable term. And you guys are getting contracts. Your first year of law school is contracts, torts, criminal law, civil procedure, and constitutional law. And so you're getting contracts 101.
The first year.
Right here. So welcome to law school.
So if you have a contract and it says, let's say, for a bathroom remodel is going to be 25,000.
Yes.
And the tile or the stone is like it's more pricier, and the wood is going up, and and stuff like that.
Yeah.
Would you need to rewrite a new contract?
You want to cover yourself to say, this contract, this estimate is only valid for a week, or 10 days. So you cover yourself. So when costs are escalating, you can go back and say, that's no longer valid.
Would you need to write on the contract then prices may vary depending on.
Only valid for, yes, prices may vary, only valid for 7 days.
Okay.
Make them, fish or cut bait.
So it's got to be there's got to be a rule, no? You can't just be this estimate is worth 3 months, right?
Yes.
Okay, so it's gonna be like,
You put it in the contract, put it in the estimate. It's valid for whatever period of time you're comfortable with.
okay.
Probably outlining the scope, right? And saying that having it, and beyond this scope, it's additional, and then maybe you can create an addendum to it.
Correct. So that's, remember, meeting of the mind. So you want to be sure that the estimate that you're giving is the same as the person is agreeing to. So you want to be as clear and as specific as you possibly can. So the other contracts that must be in writing, and these make sense if you really think about it in practical terms, guarantees, agreement to pay debts of another, including your corporation if you incorporate. That has to be in writing. Agreements to get married, contracts to buy, sell, or lease real estate. Your question about the tenants, you put the lease in writing. Credit agreements over $25,000. When you get a credit card, don't you get the pages and pages of small print? That's what they're doing. Contracts for the sale of goods over $500. So, I don't, grab and go. Maybe with your suppliers, you'll have those kind of contracts. Those have to be in writing to be enforceable. And I put in here, addendum here, you want it signed by both parties or as many parties as you have. Because when you go to enforce it, the person who you're enforcing against must sign it in order for it to be enforceable. And again, if there's a term in the contract and she says, I didn't know that, I was supposed to pay within 5 days. If it's right in there, the judge is going to look at it and say, you signed it. It's done. Contracts for lease of goods, personal property, over $1,000. And you always want to be specific and identify the goods.
Is that like a car or something?
Like a car, like the VIN, you would want to put the VIN in.
Yeah. Miles.
Yeah, the mileage, yeah. Any questions about what contracts have to be in writing?
Is it true that insurance, if you make a claim as a construction business owner,
Yes,
they always try to not pay, find a way to not pay or cover that claim?
I represent insurance companies. I mean, I literally walked into my first job after I finished clerking for a judge. Somebody handed me a case from State Farm. I represented State Farm my entire career. And, they have a bad rap. A lot of people think that. That's not the way I handled it. If you're entitled to the money, I told my client, pay him quickly. Give Ricardo that money now. So there are severe penalties if they don't. If you get the right lawyer, you see Frank Azar on TV or any one of these other lawyers. They don't do contract law. They do tort law. Remember I said the first year is contracts, torts, con law, criminal procedure, criminal law. They don't do contract law. It's entirely different. If you get the right lawyer and you have a claim and you're getting pushed sideways, you'll get it resolved very quickly. There are very severe penalties if they don't pay you properly the amount that you're owed in a timely way. Yes.
¿Qué pasa si estoy iniciando un negocio con amigos y no tengo dinero para ir a alguien a que me haga un contrato o no tengo dinero para acercarme a alguien que conozca de eso? ¿No puedo hacer algo yo básico como de que en la computadora contrato de tal cosa, tú vas a hacer esto, pero de mi parte y luego lo imprimo, lo firmamos los dos, ¿eso contaría como un contrato?
Can you help me?
Yes. So, he's like, what if you have, you work with friends, family,
Yeah.
and then you don't have money to go to an attorney? Can you write down MOU? They call it contract.
Okay, yeah. So that's a very good question. And Sophia specifically asked that I address what we call it memorandums of understanding. And we're gonna get to that, and that would be a really good first step for you with your friends to put down your ideas, who's gonna do what, and to get everybody literally on the same page. So, sorry, I needed Sophia, but.
It's okay.
Okay, let's see. So why does it matter whether or not it's in writing? Some contracts are valid even if they're just oral. Handshake deals, lots of handshake deals. And really, at the end of the day, what we're talking about is trust. Well, that's what we're talking about. Don't do business anyway, written contract, no written contract with anybody you don't trust. You gotta have trust. It's fundamental to our economy. The reason that I personally and my family supports Elevar is because the statistics are overwhelming. 45% of the economy is small entrepreneurs busting their butts like you. That's who it is. That's where the money comes from. That's how it's made. That's how I did it. I had my own law firm for many years. I went 6 months, no paycheck. Not easy. I know it's not easy for you. But this is the way it happens. If you apply yourself and you will do well. But don't do business with somebody you don't trust. It's not worth it. Okay, so contracts that are valid, even if they're just oral. Services for an undefined period. Who has the cleaning business? Yeah, you have a handshake with somebody that says, come in and clean this apartment, once a week. It's fine, for whatever you charge. That you don't have to have a written contract. It would be nice if you had a written contract, but if you didn't and you went to court, if you could show, well, she paid me $300 a week for 10 weeks, that's pretty good evidence that it was $300 a time. So you can do it. Services to be performed within 1 year, don't need a contract. Sale of goods less than $500. So if the car is more than $500, put it in writing. Lease of goods for less than $1,000. Some contracts have to be in writing. Business loans, a line of credit, payment plan. If you have a payment plan with your customer, put it in writing. What happens if the contract must be in writing and it isn't? It simply isn't enforceable. Most judges that I've worked with are good and honest people, and they're not likely to throw you out without anything, but they may impose their idea of what is the reasonable value of your services. So it just avoids a lot if you have a written contract. Okay, so just quickly summarizing, Sophia has the slides and she can print them if you want these things. Agreements over a year must be in writing. Personal guarantees must be in writing.
How do you define personal guarantees?
So if you have a business and your vendor comes to you and says, I really like you, but I want you to guarantee the debt of your company, that has to be in writing. So theoretically, your company could go bankrupt, and if you get personally guaranteed, you have to pay. If you don't have a guarantee, you don't have to pay.
I have a question again about like insurance claims.
Sure.
Is it enforceable to put like a term on there that says not responsible for accidental damages, like breaking a printer pipe or something? It's not enforceable, or is it?
You kind of have to be responsible if you broke it.
So, if you're the tenant, I guess, if I were the judge, I'd want more context. So what am I doing on that property? Am I manufacturing something that's dangerous and uses a lot of water
or just cutting holes, through the framing and stuff? Sometimes it's really hard to see what's behind it.
Yeah, I don't think that would hold up. No.
I've seen it before in other people's contracts.
Yeah. I don't think it would hold up. If you said you're going to use reasonable, if you're a drywall, I drywall. I was a drywall. If you're cutting a hole into the sheetrock that you put up, and you slice off a pipe or a piece of conduit in the process, it's inferred that I'm going to use reasonable efforts. There's tools that I can use to see if there's metal in the wall. Did I do that? I don't think, I'm not responsible in the contract that I'm not responsible for damage is going to carry the day.
What about if you're doing like a remodel and you don't know if the wood behind the drywall is rotting?
Right.
Do something like that, like
cover yourself. Say that once I open the wall, I'm going to tell you what needs to be done. Don't enter into it blindly. Yeah, I was a frame carpenter and a drywaller in college. Cover yourself. If that's the case, don't sit there with the customer and say, "Oh, it's going to be $500." Tell the customer, "Look, I got to open that wall to see how. This building has been here since 1964. I don't know what those studs look like."
You have to write it down in the contract, though?
Yes.
Or just tell her?
I would write it down in the contract. Say I'll open the wall and it's subject to seeing what's in there.
Maybe rotten or whatever.
Correct. Because it's a lot of work to pull out rotted studs, put them back, put in fresh new studs. That's a lot of work.
Yeah.
What about here in Homestead? There's homes that have very specific type of plumbing.
Yes.
That's known to be defective.
Yes.
That if you look at it wrong, it leaks. Can you cover yourself some way? Like, hey, your home has a defective pipe.
Yes.
If I'm not working over here and then it starts leaking over there, there's nothing I can do, or would you be held liable?
I would say it depends on what you did, but I would cover myself. You'd walk into that house in Homestead and say, if I work on the plumbing over here, hi, come on in. Hi. Hola. I would say, if I work on the plumbing over here, it's possible that I could move a pipe and then it's going to leak over there. Water leaks are notoriously hard to figure out where they're coming from. So I would, if that's the case, I would cover myself in the contract.
Ricardo, ¿qué desmadre estás haciendo tu mosca?
Sí, Ricardo.
¿Qué desmadre estás haciendo tu mosca?
Yeah, pues,
I'm like, what messes are you creating at the house?
¿estás previniendo?
Si entro a la casa and there's a lady alone, I'm responsible for, you don't know, maybe the husband is there somewhere.
All right, so what are some of the key terms of the contract? So some of the key terms are, who are the parties? And the parties are the people who should sign the contract. To be bound, remember, they have to sign. Scope of the work, who has brought up scope of the work? Yeah, you want to clearly define what it is you intend to do. And, look at, I understand language is a challenge, but, there are resources, Perplexity, ChatGPT, it's unbelievable the things that they can do. So just slow your roll, take the time to clearly define what you want, what you intend to do. And it's better to do it up front because you can adjust the price, you can have that discussion, or you can decide, you know what, I really don't want this job. The term, that period of time, how long are you going to do this? Ricardo, you're in the construction business, Contractors are notorious for, I'll get it done next week. Just stick to your word, Your word is your bond. Remember, you want to do business with people you trust. And be trustworthy. It's a two-way street. Be trustworthy. Do what you say you're going to do, when you say you're going to do it. Are you going to give warranties? These are promises. Are you going to say, my work, I'm guaranteeing my work for X period of time? If you're going to do that, specify it. And damages clause, and this is, I don't want to get too complicated, but there are liquidated damages. You can say, if I don't properly perform, or the other party doesn't, hi, come on in, sorry. No worries.
You can sit here if you want.
Yeah. I'm Rick. Okay, warranties, damages clause. So there are liquidated damages clause, and if you see these in a contract, really, take some time to think it through. They could say, if you don't hang that sheetrock, and these are really happen a lot in construction contracts, you're going to be responsible for X a number of dollars.
Per day.
Per day, right, yes, exactly. Every day that you don't perform.
If you don't finish
If you don't finish,
by the time you said,
yes.
that's what damage.
Liquidated damages clause. Liquidated damages clause, so be careful.
What if you put on the contract like, time may vary depending on like stone or.
Right. You can do that and, strike that liquidated damages clause. Because you could say, I gotta go get the stone.
So what happens when you have your contract and the commercial or entity that you're working for has their own contract?
Yeah.
Which one takes over?
Did you sign, which one did you sign?
If he didn't sign none of them, then it doesn't apply to him? Like if.
Then you just set yourself up for a big lawsuit.
No, but like if he didn't, like if they just had a contract, but he didn't sign it, but they signed his contract.
Then his contract controls. Yeah, the contract that you signed, if you're gonna be bound and you signed it, that's the contract you're gonna be bound by.
And then
If they have a form contract, there are a lot of big companies, you're gonna be a subcontractor, right? You're gonna work for a general. And most generals have their own contract forms. Read it before you sign it.
If you don't like it, don't sign it.
If you don't like it, then don't, or tell them why you don't like it.
They can't use your signature, like if you sign something else, use it for that?
Nada. No way. If they do that, that's fraud. That's fraud. So if they do that, call a lawyer right away. Don't wait around.
And also they're maybe starting their business and they have contractors coming over to fix that. Just make sure you have a contract and you put like contractors, because it ends up being Ricardo's responsibility when some contractor does something in a house and he messes it up.
That's
so
right.
maybe have a word there about
That's right.
the people that works with you. And
Right,
their
so if
liabilities.
you hire a sub, then you should have a contract, because as Sophia said, if that sub that you brought into the job damages the plumbing, they're gonna look at you.
I can ask them to put me under insurance, right?
Yes, you can ask your subcontractor to put you on your subcontractor's insurance. Does that make sense?
Contractors, because they're not employees, you cannot put it on insurance, or they have to have their own insurance because they're
It
contractors.
depends on the terms of your contract. There are many policies for construction companies that will allow you to hire subs, because that's what you do. I mean, that's a part of the business. So you got to look at your policy. But that's a very, I would be surprised. Who's your insurance company?
Acuity.
Acuity is, I represented Acuity. Acuity is an outstanding insurance company. One of the best. I did construction disputes for Acuity. I would be very surprised if you don't have coverage for your subcontractor's work. I'd be very surprised. Now, yeah, I would still encourage you to have your subcontractor put you on the subcontractor's insurance. Why? Because now you don't have to go to Acuity. You go to the subcontractor's insurance. You make a claim. You make them pay. That doesn't affect your loss ratio. You know what loss ratio is? So insurance companies evaluate you based on your loss experience, how many claims you make. The fewer claims you make, the cheaper the policy. So if you make a claim under your subcontractor's policy, it's good for you. It's not on you. It's not on you. Are you going to get insurance?
Yeah.
Yeah, good. Good. All right. Yeah, I mean, these are the realities. That's the way it really happens. Dispute resolution. So this is a good term. I would encourage you in all your contracts, put in an arbitration provision. You tell the parties you're dealing with, no court, arbitration. It's cheaper and faster.
Arbitration is just like a setup, like
it's like, there's the American Arbitration Association, and there are different companies, and you hire a former judge, and these guys are great. I'm telling you, these men and women are really good. They want to be fair, and the only way they get more business is if they're fair. Because if you badmouth, you say, "Oh, Judge Sudicum, he's an asshole. He's not fair. He didn't like me. He didn't treat me well. He wasn't respectful." I'm not going to get any more business. So I have to be fair. I have to be fair to everybody. Everybody has to come into the room and say, "You know what? I had my day. He listened to me. He heard me. He may not have agreed with everything I said, but he treated me fairly." That's the kind of guy that's going to get business, and your attorney will know who those people are. So arbitration is the way. Please put that in your contracts. So, Sophia really made a point, said, "Rick, talk about how it is that we're supposed to really review these contracts." And it's hard. I get it. They're complicated, time consuming, and you have to really give yourself some quiet time, and you want to understand the big picture. What am I trying to accomplish with this contract? And maybe it's easy. I'm going to build the Smith residence. It's or put up these walls. I'm going to this work. But look at the big picture and read the entire agreement. Because buried in the back are going to be things like arbitration provisions and liquidated damages clauses. And you can go through these contracts, and if you don't like a term, strike it out, put your initials, and date it. Now you're not bound. It's just that easy.
And then you can sign.
And then you can sign. and you didn't agree to the term you don't like.
Just crossed out.
Just cross it out, initial it, and date it. Now that term is out. You can't be bound.
But then the other party may say, okay, no
Yes.
deal,
Yes, exactly.
because you didn't.
Right, so in legal terms, this is back to Contracts 101. Now you're making an offer with the new contract, with that term deleted. Now it's their turn to accept it, so you need their signature as well. So even if it's signed by the other party and you don't like a term, cross it out, initial it, date it. Done. End of that problem. So review the key clauses. Use a highlighter. I'm old school. I have binders and highlighters, and that is the way my little feeble mind works. So that's what I do. And if you have a question, ask the other side. Be sure that you understand, so that you come to the meeting of the minds. And if you have any doubt, hire an attorney. Okay.
Acá, venga.
Welcome. Come on
Ahí hay
in.
una silla, si quieren.
Oh yeah, here you go.
¿Y necesita traducción? ¿No? Okay.
I think we met, right? You're the collectibles.
That's the bit.
Collectibles.
Yes, exactly.
All right. All right. So if you have any doubt, hire an attorney. What I was going to say is, Sophia is a wonderful resource. She can reach out to me. That you have resources that you can utilize to find somebody who can handle your case. Use your resources. Don't, nobody's an island. Don't sit there alone and think you can't get through it. Reach out for Sophia. She needs my help. I know she'll call me. Okay, so what are the best practices? We talk about best practices in business, which is what are the best ways for you to conduct your business? Here they are. When in doubt, put the contract in writing. And if the other side doesn't like it, that's going to force a discussion. That's good. Use clear, specific, and simple language. The KISS principle, does everybody knows the KISS principle? Yes, thank you, yes.
Easy, simple, and stupid?
No, keep it simple. Stupid, me, right. Stupid, yeah. Okay. So the best practice is for both parties to sign any written agreement. Now, you don't have to sign contracts because you may not want to be bound, but if you want to get the other side to pay you, and you better be sure that his signature is on the contract. And it really is the best practice for both parties to sign the contract. Keep copies of all these documents.
How long should you keep store them?
Well, the tax code says 7 years.
7 years.
Yes. That's tax law. So, I'm a big believer in Murphy's Law. Does everybody knows Murphy's Law? Yeah, right. So if you keep it 7 years, you'll never need it.
Yes.
That's Murphy's Law, right? But if you don't keep it, I guarantee you'll need it.
Once you throw it away, you need it.
Yeah, exactly. Have questions, call an attorney. So like I said, we can help you with that if you need it. Okay, so memorandums of understanding. So my friend, amigo, so here we go. So now we're talking about, so you're in a very preliminary stage. You're talking with your friends and family about starting a business. It happens all the time. So you might want to use a memorandum of understanding. In Colorado, it's a written agreement that records the parties' shared intentions and the basic terms of what we propose to do together. It's not necessarily a fully enforceable contract, but this is a first step. You follow me? Okay, good. A memorandum of understanding is used when two or more parties agree to a common course of action and want to memorialize what they intend to do. So there's a written document that we can both refer to say this is what we intend to do. So it typically outlines the purposes, roles, responsibilities, so on and so forth, and expressly states that it is a voluntarily non-binding agreement. So nobody has to feel threatened. That's the point of it. It's just, you're dipping your big toe into the water of this new business. Does that make sense?
I think it's very important that they outline the responsibilities first and which roles each are gonna have.
Right, exactly.
Because when you're starting, maybe they all do the same, but okay, what I'm doing here, what do you have to do? Because if something happens one day,
yes, exactly.
it was your responsibility to do this and that, and then everybody's on the same page.
That's a very good point, Sophia.
But you can't prosecute it because it's not a contract.
Correct.
So it's just like.
It's just a first step, so you're considering starting a new business. You use this for a month or so. See, remember, we're talking about, can we trust these people?
It's just like enforcing responsibility.
Not even that, it's just like setting forth, getting understanding so that you can have a real meeting of the minds in the future. Exactly.
But if you go to court, suppose you put an MOU, with an MOU and they both sign, so
Yes.
Eddie signs, Sophia signs, and I go to court, will that protect me or him? Or
As long as the other terms are met, remember, offer acceptance,
Yeah.
meeting of the minds, consideration.
Okay, so it's for
So if you-
starting, it's good.
It's very good. It's a very good first step. I wouldn't say use it forever, but I would say very good first step. So does that help you with your new business that you're considering? Yeah. I mean, finance is a complicated field. So, yeah, I mean, I find, like even preparing this, sitting down and writing, for me personally, that's really the only time I think clearly.
There's another type of insurance, right? You have liability and then you have something for like consultation.
Liability, yeah, so there's first-party insurance and third-party insurance. First-party insurance covers your property. Third-party insurance covers your liability. Did that answer your question?
Well, for instance, let's say you're doing consultation and you say something that causes a problem. Is there
Yes.
insurance for that? Would that be liability insurance? Or
That's errors and omission. That's a form of liability insurance. Yes, so there is a very specific form of insurance to cover your exposure for the advice you give. Attorneys have errors and omission, malpractice insurance commonly referred to, but it's a form of errors and omission.
Good to know.
Yeah, good to know, exactly. Good insurance agents, it's good to have. And, I'll make the same offer that I made about attorneys is if you need help with that, reach out to Sophia. And if she needs assistance, I know she'll call.
I know this person, I can help you.
And then, why would some insurance, let's say I call her, when I start my company, I call around to like insurance people.
Yes.
And then I went directly with Acuity and the prices were like completely different. Acuity was way less than going with someone getting insurance from me.
Two things. So did you get written quotes from all these companies?
No.
So that's what I would do is get written quotes, and then insurance is complicated. And, like I said, there are different clauses and coverages available. I know this, this is what I did. And you have to be sure that it's apples to apples, that you're getting quotes for the same coverages. It's complicated, so you want to put it in writing. Acuity is a good company. So I have a lot of faith in Acuity. I met a guy at Acuity 25 years ago, gave me a shot, and I represented them for the rest of the time.
And what's an umbrella?
An umbrella is, so you have an automobile insurance. Let's say your automobile insurance is for $200,000. An umbrella goes on top. It doesn't kick in until that $200,000 is exhausted in insurance terms. So if you run a red light, hit another car, guy's a quadriplegic, is going to be in a wheelchair for the rest of his life. Your damages are $2 million. Your auto policy will pay the first 200, then the umbrella. That's an excellent question, Ricardo. Umbrella coverage is very cheap. It's very cheap. Get it.
Does Acuity have something like that?
They do. They do. Umbrella coverage, umbrella liability coverage is cheap insurance. Get it. Murphy's Law. You got it. You won't need it. Okay. Let's see. Okay. So in practice, how are memorandums of understanding used? They're used a lot with nonprofits and state agencies. It's, because Eagle Valley Community Foundation is going to do, business with various grocery stores, are going to give food when it's out of date. It's just, so it sets forth, this is how we're going to work that arrangement. It's a good first step when you have a contract. But yeah, that's how they're typically used in this location. Enforceability, yeah, as Sophia pointed out, memorandums of understanding can be enforceable as long as the 5 elements that we've discussed, offer, acceptance, consideration, specificity, the signature, as long as those are met, they're going to be enforceable. But frequently, they're going to lack some of those terms because you're going to use it as a first step in establishing your business. And many will expressly state that they're not enforceable. And again, that may be just something you want to do to begin this relationship. Okay, so typical contents of memorandum of understanding. You want to identify the parties in a statement of purpose. You want to describe the mutual interests, responsibilities, roles, information sharing, and so they're often without a fixed duration. Again, this is just kind of a preliminary first step of what you want to do with a particular business partner. So practical use of memorandums of understanding, it's a framework for sharing information. That's really what it is. You're laying out with your partners what you intend to do, how you intend to do it. As we've discussed several times, it's a preliminary statement before entering into a full-blown contract. It allows coordination of projects without commitment and establishes a protocol for sharing information. MOUs aren't enforceable unless they meet the elements of a contract. Clarify if the memorandum of understanding is to be binding or enforceable. define each party's role and responsibility, and consider a dispute resolution provision, as I've said a couple of times. All right, that's what I have for you. We have some other exercises to go through, but before we do that, what questions can I answer?
Is it possible to have like multiple insurance, or is it just one with bigger coverage?
It's possible to have multiple, but it's better to just have one with bigger coverage. Because there's gonna be cracks between multiple carriers that you're gonna fall into. So I would have a primary layer, that first 200,000 of automobile insurance we discussed, and then a second layer, this umbrella to cover you.
What about liability insurance?
Then this is liability insurance.
What would be like a good limit or minimum for doing work like in Cordillera and stuff?
So you tell me what you think, what in your worst nightmare, what's your exposure?
Complete house burning down?
Okay, so $1 million?
No,
How much?
I don't know. Like
500,000?
Like 5 million.
5 million.
$5 million.
Okay, 5 million.
Yeah.
5 million, yeah. Yeah, 5 million, okay. So I would have $1 million layer, and I have a $5 million layer.
You do an umbrella.
Yeah, I have an umbrella for $4 million on top of my $1 million primary layer. Yes.
No, pero no manches, ya fuera aquí.
I'm understanding not to hire.
Pardon me?
I'm understanding not to hire.
Gotta be ready.
Yes,
Can I share my experience?
please do.
So we had we have to review a contract. Our client gave
Yes.
us a contract, and it's a document you don't want to read, right?
Right,
But what I did, I used artificial intelligence and take section by section, explain this to me and how this
Yes.
is related to my business. And I learned a lot just by doing
Yes.
it. And then I had very specific questions to bring to my lawyer. And
perfect,
then she did the writing.
yes,
I cannot do the writing. I don't know the law enough
right,
to do the writing, to
Yes.
modify any section. So she did that based on what she does, right?
right.
Her
Your homework, yeah,
expertise.
yeah, right, and what you brought to her.
Yeah, so that allowed me to understand the contract.
That's an outstanding strategy. That's a great strategy. Everybody hear that? So she used artificial intelligence to go through each term of the contract so that she understood what she was doing. Great strategy, great
Yeah.
strategy.
But my advice is don't trust too much, or don't rely too much on artificial intelligence.
Yes.
Because you need an expert. You can make AI to tell you what you want to hear,
Yes,
right? So at the end of the day, you need
you need a lawyer, you need a good lawyer, but it's a good first step to understanding, at least to spend the time, like I said, the big picture, to get the big picture, then go through and parse out each piece. That's a great strategy. Yeah,
And then-
but you do need a lawyer. You're 100% correct.
Rick, and I'm thinking about Monica. Or maybe the massage therapist. Suppose they're working with people and she's not a doctor. So what she says, so maybe someone can come back, suppose this. I went to Monica's workshop and she told me to drink this and that, and then I'm thinking and I all had these hives. So I will say, just put a note there is,
I'm not a doctor.
like, I'm not that this is just informational only, so to cover themselves for
Yes,
any reason.
absolutely.
But maybe in your flyers or in your workshops, just
Your
put
videos?
something there that says,
All of those things.
Non-clinical.
yeah, no click, just informational purposes, you know what I mean?
Right, exactly. I think that's very, very good advice. I mean,
Like right now on my social media post, at the end of my post, I have like I posting like information about the video
Mhm.
and description about the video, and I'm saying I'm just suggest what it helps to me, but I'm not a doctor.
Right, that's very good.
That's how I can protect myself,
Right,
right?
right,
And
yes.
if I have a, like, I'm just to do Zoom and I can do advertise to women, but I always gonna say, I'm not a doctor. I'm just gonna give you an advance how it helps me. And if it works for me, it can be works for you. But I'm not a doctor. Before you try something, go to the
Doctor.
specialist.
That's very good advice. You know, and you brought up you needed help with protecting your social media posts. And I'm not an intellectual property attorney. That's what you need. You need somebody who knows how to register, trademark, protect your content. That's, that is something entirely different than I've ever done. So I can't really help you with that, but that's what you need, an intellectual property attorney.
And an LLC, like a corporation, like an entity. So if something happens, they don't go after her.
Yes. You have an LLC?
Yes.
Oh, good. They'll try. I mean, all you need to file a complaint in court here is, a piece of paper and pay the fee. So, you can protect yourself. You've tried, but, they can still drag you into court.
And then another question regarding people that have like food trucks or business. You have to post stuff from the state. So always post,
Oh, yeah, right.
how you call those things?
Workers' comp,
Workers'
yeah,
comps, and
yeah.
then, but also post. So this fryer needs to be at this, what it says?
Temperature, yes.
Temperatures and things like that are right there. So
Right.
if something happens to your employee, it was written, it was posted,
Yes.
it was in your description of responsibilities or scope of work.
Right.
You know what I mean?
Yes.
Because we're gonna have issues too, like that.
Very good. That's very true. I mean, yes, basically you're saying you've got to comply with the law. Yeah, you got to comply with the law. If you're a food truck business, and the food truck business says you need to post information about the equipment that you're using, that's what you got to do.
What about posting like calories, allergens in your food that you use?
What with what in the food?
Let's say you
The nutrition information?
Oh, nutrition information.
Yeah.
I don't know that. I wish I did, but I don't know that. I don't know what's required. Do you know what's required? What nutrition information you have to put down?
I think it depends. From what I've heard and learned is that if you're like selling it and giving it to the person, you don't need to have the nutrition on it. But if it's on a shelf and the person is like going and grabbing it themselves, then you have to have the nutrition.
Oh, that's a good. I mean, that corresponds with my experience. You go to Rocky Mountain Taco. They don't say 325 calories.
Because they're giving it.
Yeah, right.
No, maybe the expiration date needs to be there, or when it was elaborated. I mean,
If it's on a shelf, yeah. If it's
Yeah,
on
you
a
have it
shelf,
on the shelf. Yes.
Otherwise, it's like
Yeah.
good to know.
Right.
Yeah. You can only hope.
Right.
What other questions? How about you guys? Are you guys comfortable with what you need to do to start a business?
Like, what if they cut like someone's ear? Like, what?
You come up with the
La pegamos.
Eso no. Like,
Acá venden buenos pegantes.
oh my God.
Eso sí.
A question.
Yes.
So I'm thinking about the contracts that don't be to need a right.
Yes.
What about if one party doesn't fulfill anything according with the agreement?
Right. So if it's not in writing, it doesn't have to be in writing, and the party doesn't perform, and you've got all the other elements, offer, acceptance, meeting in the mind, consideration, you can go to court and get it enforced. Now, it's going to be harder, but you can get it enforced. And like I said, the judge is probably gonna give you the reasonable value of your goods or services.
Okay.
¿Y cómo protege?
Y manejar reputaciones de animal, de que no vas a usar mi imagen o mis videos para eso.
What should we do next, Sophia?
How about another question?
Okay, sure.
Sácalos todos.
Oh, you're good. These are all good questions.
Yes.
He's asking, what if you only burn half of the house?
That's what I'm wearing.
Or what if you cause like a wildfire out there? So my question is for money, what if she starts selling products with her brand? Like who would be liable if, let's say she buys this from someone else and then she resells it? Who would be liable if something happens?
So if she's just a reseller
Yeah, but with her brand.
with her brand,
They should rebrand
Yeah,
it.
how I gonna protect my brand that somebody has not done resell, right? My own brand or my.
Because we need to register, no?
Like if I sell like
Yeah.
a burrito, let's just say I sell a burrito to someone else and like a restaurant sells my burrito, like
Yeah.
who's liable, like would I be liable or the person selling it?
both would probably be liable. You know, you would both parties would be sued, and then they'd be pointing the fingers that you would say, I didn't make that burrito, he made that burrito. I just resold it. He's responsible. So, yeah, so you pay a little bit, he pay a lot more. But both would be sued.
Same type of money.
Yes, so you have an agreement with two people in a business or three people in a business. It can be friends, it can be family,
Yes.
it can be. It's a verbal agreement.
Okay,
How you part ways to be in good standing with them.
okay.
So would you say 50-50? Would you say depends on?
I would say, you know, it depends on what each party did. If both parties are working, if I'm establishing a drywall business with, what's your name?
Okay.
Jorge, right, Jorge. If I'm establishing a drywall business with Jorge and we're both working, you know, we're both buying materials, we're both doing the job, yeah, 50-50. But what if, you know, I'm just the money guy
I'm working.
and you're working? You know, I want my money back, right? Or I
So
want to.
like 60-30.
Yeah, I would, you know, it would, what's reasonable, you know? I mean, maybe you gave me some money, maybe I put 5,000 in and you paid me back 3.
Is this when the beneficial ownership percentages would take place?
Beneficial ownership, it could. So beneficial ownership, so in the law, when we use the term beneficial, we normally mean implied ownership.
So one's more owners than the other.
Yeah, exactly. A mediator or a judge would he'd want to sit down and talk to both parties, figure out, you know, how much time you spent, how much money I put in, then he'd give you the reasonable value of your services, and my money would be, you know, that's what it is. And then he'd work out a deal where it's equitable. So beneficial ownership means basically the judge is going to be equitable. He's going to be fair to both parties. In law, there's courts of equity and courts of law. Equity is all about being fair. Law is about enforcing the terms of the
What it
contract.
is.
Yeah.
I have another question if you guys don't mind.
Yeah, no, this is great. You're good.
So let's say I wanna work with someone else, but I don't wanna be like, I just wanna be like passive.
Yes.
And let's say they hire people that they shouldn't be hiring and something happens and stuff like that. Is there any way in the contract that I won't be liable? Or let's say if I'm 30% owner, I'll be 30% liable for whatever happened?
Or would that then go into him having a subcontractor and the insurance taking?
So here's the real world
I
example.
think he wants, tú quieres trabajar con alguien más, ¿no?
Sí, por decir, hacer una compañía con alguien más, pero no
Que es
quiero
la
manejar.
nueva. Que es la nueva y nomás es como tú.
Sí, conseguir trabajo, sí, sí, pero yo de contratar y así. Pues, no me gusta.
So you both, here's what would happen in real world. You both would be sued. Then it's a fight between, so the injured party is gonna sue you and your partner. Then you and your partner are gonna argue about how much each party has to pay. Each of you have to pay.
Would you have to have like a lawyer involved?
You just have to have, I mean, either come to an agreement quickly or get a lawyer.
Can you have like on the operating agreement, like a clause that protects you?
Yes, you can, yeah, absolutely.
Just put it on the,
Like not responsible for hired people or
contract.
something? Or what?
Yeah, you could say,
Or part owner not responsible for?
so it would depend on, were you careless when you hired this guy? In other words, you hired a guy to hang drywall.
No.
We never hung drywall before.
Okay.
So if that person caused damage, you're on the hook, and he's on the hook. He hired you, and you hired him, and you didn't know what you were doing. You didn't hire somebody who knew what they were doing.
No, but I wouldn't hire him, let's say, me and him.
Okay, but if your partner,
Hire him then.
so in the law, partners, unless there's a written agreement that specifies the percentage of liability, I think this gets to, it's 50-50 for partners. So corporate organizations, there's sole proprietorships, there are LLCs, there are companies, and there are partnerships. Partners by nature are gonna be responsible 50-50. You're on the hook.
As partners, not, what did you say, ownership,
Sole proprietor,
right?
yeah, so sole proprietor's on the hook. Yes,
So my best friend and I wanted to work together to deal with some clients who wanted some couples massages and four-handed massages. But we each have, I have a sole proprietorship, she has an LLC. Do we just come up with like a MOU?
yes, that would be great.
Okay, and that just makes sure that.
Yeah, everybody understands what they're supposed to do.
Right.
And you could do that very simply and easily, because you've done this and you know what you're doing.
Right.
Right.
Okay.
And you just want to be sure.
Forehand massage?
Yeah.
Okay.
Sounds great.
Sounds amazing.
My mom can attest.
Yes,
Correct me if I'm wrong,
okay,
but let's see this from the other perspective, that it's not about if they are partners in a business. Is if I'm gonna sue someone, I wanna include in this lawsuit the more people I can, because he has his insurance, he has insurance, and so he has insurance, and she was just cleaning, but she has insurance. So I'm gonna include all of them, because I am increasing my chances of getting paid. So at the end of the day, how can I say this? You cannot protect too much, because it's as you say, you're gonna get sued anyways, because it's a business. It's somebody's chasing money, chasing the money of your insurance. I don't know if I'm saying it right.
you're saying it right. It's a well-known legal strategy. It's the shotgun approach. You shoot the gun at everybody. It's like a shotgun. It has a big wide pattern. So you sue everybody, because that, like as you said, that increases your chances of getting paid. Now, there's going to be separate lawsuits between the defendants. Then there's going to be 5 of these people. Then they're gonna fight and sue each other on who has to pay what.
But
So you can protect yourself at this layer.
yes, but if Jorge has his insurance,
Yes,
Ricardo has.
yeah.
What is it?
Ya se fue, ya dijo, "Nah, ya."
She ran
It's already
away.
made.
You're not gonna use my
Too
insurance.
much lawsuit for Ricardo.
Okay, Ricardo has his insurance, Jorge has his. So they're in good terms.
Yes.
They are protected.
Yes,
This is now their insurance
yes,
problem.
That's
And
right.
they keep doing
Yes.
businesses. So this is a way to protect partnerships, and everybody has to have the right insurance
Yes.
to make the business.
Can you say that again on the spot?
Yeah.
true. Any other questions? I think we've used our allotted time, Sophia.
It's perfect.
So let's say,
Yeah,
I'm doing a remodeling,
yes,
there's like, scratches and dents on the floor and stuff. But I had seen them before.
yeah,
I
yeah, yeah,
started.
yeah.
Do I write that in the contract or just? tell
And
them?
take pictures.
Take pictures.
Take pictures.
I take pictures all the time.
Yeah, okay, good. And then write it on the contract, yes. Jorge,
Verbally is different, right?
verbally is
It won't
different,
count.
yes. It's important, but put it in writing and say it verbally. And take pictures.
Yeah.
Murphy's Law, you gotta be willing to need them.
But also when you pay for a service, and that happens all the time, I have the right also to let them know what I'm expecting from them.
Yes,
Because, okay, you give me the estimate, it's like, the windows cost me $20,000 to replace in the house. They're gonna be done in how many days? 3 days, okay. They're not done in 3 days. So now it's like your responsibility to come and do the work. So I don't wanna get into an arbitration or anything, but
you just want the work done.
it's like, so that comes the responsibility of the good standing of how you trust the people you work with. Because if like, dude, you put the windows and then with 10 employees and then the second day there's 2 and then the last day 3 and then it's taking longer, so, well, I'm not gonna agree to, you know what I mean? But you
Yes.
have also the right to enforce that.
You do, and Jorge may say, I would have put those windows in, but the stud walls were,
I need to
Studs
do
for-
reframing.
yeah, it needs to be reframed. So, yeah, you're right. At the end of the day, do business with people you trust. But also, be open-minded, construction is complicated.
Super.
And stuff happens. And keep an open mind.
Yeah, but-
Don't use the lawsuit word, on day 4.
No, but also I want them to understand another responsibility they have. If they cannot make a job properly, don't take it.
Yeah, don't take
If you
it.
don't have the people to do a good job, don't take it because it's gonna be bad for your reputation first. Second, you don't have the experience or the people skilled to do that. Third, just take more time. Don't just take more than you can handle.
That's how you get the experience.
Well,
Well, like something that you gotta bring people in.
Ricardo's gonna get the good
He
insurance.
said you
The umbrella. No, but first you start working with someone that has experience. So it takes
Yes.
you, brings you up to the
Yes, you
job.
need a mentor, somebody who knows what they're doing.
So Rick, one last comment.
Yes,
Recently we prepared a contract for this lady, and she came and she just signed it. She trusted us so
Yes.
much that just signed it, and she didn't read it. She didn't took the time to understand what she was signing, and that makes me a little bit worried,
yes,
right? Because my point is we need to get into the habit, the good
of
practice
explaining,
of explaining it, but also reading.
definitely.
Understanding what are
Definitely.
we signing.
That's a very, very good point. I used to tell people, you want me to take your case, okay, but it's a partnership. We're gonna have to work together. And your point is, if you're in business with somebody who isn't working, who's just saying, I call it a sign and resign. They sign it and then they just walk away and say, oh, handle it. That's a recipe for disaster at the end of the day. It really is.
So what we can do is at least explain.
You explain,
And-
you say, no. You can't sign that yet. You can't sign it. Let me just go through it. And you go through the important points with her. And then you say, now you can sign.
Okay.
Yeah, make them, yeah, say, no, not yet. Yeah.
But if they sign it quick, that's not up to you, like you put your rules down.
All right, then the judge is gonna look at you and say, did you see him make a contract?
Well, I mean, that's, I
Yeah,
did see
yeah,
him read it. I mean, they can't do anything there.
You're right, I
They
mean,
signed it.
you're in a better position, agreed, but it's not the best position.
It's not,
Yeah.
You signed your form.
it's not good moral wise,
Yeah,
but
yeah, exactly. And yeah, this is important. Yeah, at the end of the day, as Sophia said, you want a good reputation. You want people to say, I know Jorge, he knows what he's doing. He's not gonna take a job that he can't do without, he's gonna take a job. Yeah, exactly.
Como hacen sus videos, puede decir.
A ver, ¿qué puede decir?
Díganos, licenciado.
You won't believe that Ricardo, 6 months ago, was the shyest person in the world.
You're right, I don't believe it.
No. ¿Algo más? ¿Alguna pregunta? ¿Ustedes? Okay. Everybody good? ¿Alguna pregunta usted? Nada, por acá? Okay.
Well, it's a pleasure to be
Thank
with
you,
you.
Rick, so much.
You're welcome. Like I said, entrepreneurs are the backbone of our economy. You are what makes this country. You're what makes the country work. So don't believe anybody else.
One thing is like the jurisdiction. So if you're working in your county
Yes.
and you have a contract for your county, it may be different than if you go to California.
Oh, definitely,
Okay.
definitely. Yeah. So, yeah, that's a whole civil procedure question, but, yeah. You want to enforce the contract where you do business, and that's a good term to put in. You're gonna say, Eagle County Courthouse.
Yes.
That's a good term.
Thank you, Rick.
Yo creo que él sepa así como de nuestro caso, algo así, comentar algo de cosas.
Ah, really?
Un saludo para mi mamá. Que me está viendo de la sala.